seated. Good morning. Good morning. Oh, y'all sound very refreshed. All right, we're ready to get that started. State, you may call your next witness.
The state calls Special Agent Brock Sain.
Stand right here. Raise your right hand.
You swear affirm to tell the whole truth.
Yes, ma'am.
All right. Have a seat, sir. If you could speak loudly so the jury can hear you, why don't you try to push the back of the room for me, please? All right, you may proceed.
Good morning.
Good morning.
Could you state and spell your name for this record, please?
Brock Sain, B-R-O-C-K, last name Sain, S-A-I-N.
And Special Agent Sain, where are you employed?
I work for the Tennessee Bureau of Investigation.
And how long have you been with them?
I'm on my 16th year.
And what position do you currently hold?
I'm Special Agent in charge in the Administrative Services Division over the support unit.
Okay. Have you always been in that division?
No, I have not.
Where were you prior to that?
Prior to that, I was a Assistant Special Agent in charge in the Medicaid Fraud Control Division. Prior to that, I was Special Agent Investigator in the Medicaid Fraud Control Division. Before that, I worked in the crime lab here in Memphis as a Special Agent Forensic Scientist. I worked in the Drug Identification Unit and the Firearms and Tool Mark Identification Unit in the crime lab in Memphis.
Okay. So when you were in the crime lab, what did your job duties entail?
When I was in the Firearm and Tool Mark unit, that was from 2016 to 2020, roughly around that time, and I identified, examined firearms and ammunition components to determine whether or not those ammunition components were fired in a particular firearm and if the firearm was in operating condition.
So prior to the TBI, could you tell the jury a little bit about your educational background?
Yes, I have a Bachelor's of Science in Forensic Chemistry from the University of Mississippi. I graduated from there in 2009.
And have you ever testified about your findings in a firearms report?
Yes, I have.
How many times?
I don't know the exact number. In firearms, more than 10.
And have you ever been qualified as an expert witness as pertaining to firearm identification?
Yes, I have.
Do you know how many times?
All of those, 10 to 15 times.
And was that in Shelby County or other counties?
Other counties, federal court here in Memphis, and other counties across West Tennessee.
Your Honor, I would tender Special Agent Sain as an expert in firearms identification.
No objection.
All right. We'll tender Special Agent Sain as an expert in firearms identification.
Agent Sain, I'm going to pass you a document. Do you know what that document is that I just passed you?
Yes, this is a copy of my lab report for firearms identification on a TBI lab case.
Okay. And was that case involving a homicide that involved Miss Latoshia Daniels?
Yes.
Okay. And you completed that firearms report?
Yes, I did.
Your Honor, if we could enter the firearms report into evidence as the next number exhibit.
Any
No
objection?
objection.
All right, we'll show Exhibit 20 as the firearms report.
Thank you. You can pass that back. Yes. Thank you. So, Agent Sain, what evidence did you receive to make that firearms report?
I received a Ruger EC9S 9mm Luger pistol, a magazine and some cartridges. And then I also received 7 9mm cartridge cases from a crime scene. And I received 6 bullets from the Shelby County, from the medical examiner's office.
And who did you receive all of that from?
It was received from Chris Roberts from Collierville PD,
Okay. Do you remember the date that you received all of that?
April 10th of 2019.
Agent Sain, I'm going to pass you what has previously been marked as Exhibit 3.
Okay, you're against it.
Thank you. If you could open that up and tell us what you see.
It's a Ruger EC9S 9mm semi-automatic pistol.
Okay. And is that the same gun that you received from Detective Roberts?
Yes, it is.
Okay. And Agent Sain, I'm going to pass you what has already been previously identified as Exhibit 6. And what do you see?
Evidence received from at the TBI crime lab with my markings on it, my evidence tape, and it's the evidence examined and reflected in this report.
Okay. And for all of that evidence that we just went through, were you able to analyze all of
Yes.
it? And did you compare the Ruger handgun to the bullets and casings that are in there?
Yes, I did.
Okay. And the bullets and casings, were they found on the scene and from the medical examiner?
According to the submittal form, yes, they were.
Okay. And could you walk us through what you did when you examined them?
Yes. You ready to just talk about, in general, the firearms? And so in the laboratory, we take the firearm, if there's a firearm in question, take it in the laboratory to examine it. So I would do test fires. Take that firearm, and we have a tank in the laboratory full of water, and it's a stainless steel tank. Shoot that firearm into that tank and collect known bullets and cartridge cases that were fired in that gun. So those are my knowns. I know what those have. I look at those under a comparison microscope to look at the individual characteristics or the mechanical fingerprint of that firearm that were left and impressed and scratched upon those cartridge cases and bullets by that particular firearm. If I have evidence pieces such as these, bullets and cartridge cases, I take those and compare those under a comparison microscope to see if they have those same individual characteristics as the known test fires from that particular firearm. I look at those under the comparison microscope to determine if they were fired from that particular firearm or not.
And did you bring anything to demonstrate the test fires to the jury?
Yes, I did. May I use it in front of the jury? So, may I step down?
Yes.
So this is an aid to help you see what I'm talking about. This is a cartridge. So this is what the ammunition is loaded into that semi-automatic pistol. It's loaded into that firearm. When the firing pin strikes the rear of this, the bullet, there's an immense pressure in the back. It pushes the bullet down the barrel of the firearm. So that bullet travels down the barrel of a firearm. Inside that barrel, there are raised areas, lands in grooves, and it looks like the stripes of a candy cane. So the point of that is to put a spiral, like a football, onto that bullet so it can go towards its intended target. So once that bullet is forced down that barrel, it's scratched by that metal, that hard steel inside that barrel, and the scratches are left upon that bullet. I examine those scratches on that bullet compare them to my known test fires. I do the same thing with the cartridge case. The pressure of that firing of the bullet down the barrel presses it against the rear part of the firearm, and when it's ejected, there's also other scratches that are left on the cartridge case. So I can look at a cartridge case and compare it to another cartridge case, or a bullet compared to another bullet. And that's how I can identify whether or not they have those same individual characteristics from that firearm that were placed there by the firing of that ammunition down the barrel.
Thank you for that. I do have a general question. So is it unusual to have a shell casing but not have a bullet?
No, it just depends on the situation. A cartridge case is ejected from a firearm and usually lands a few feet from where that firearm was. A bullet is fired down the barrel of a gun, and it can go until it comes into contact with something or until it runs out of speed or energy.
So specifically for this firearms report, what were your results?
So the results of this testing was I examined the firearm, and it was in normal operating condition and the safety features functioning. There was a cartridge and a magazine. There were cartridges and a magazine. And then once I test fired that firearm, the test fired cartridge cases and bullets from Exhibit 1A, the firearm, were microscopically examined in conjunction with the cartridge cases in Exhibit 2A. There were 7 cartridge cases and the 6 bullets in Exhibits 2B, 3A, 3B, 3C, 3D, and 3E. And based upon the comparative examination, sufficient agreement of those individual characteristics, all of those ammunition components had been fired in that firearm.
Okay. So all the casings or the bullets have been fired from that Ruger?
Yes.
So if you could take a look at your report one more time. How many bullets came from the medical examiner, and were there any other bullets found in the scene?
I received 6 bullets. One of those was from the crime scene, and then the rest of those were from the medical examiner. So one of those says it was from crime scene.
No further questions, Your Honor.
Cross-examination.
Yes, Your Honor. Good morning, the detective Sain, not detective.
Agent Sain.
Agent Sain.
That's fine.
Special Agent Sain.
Yes, sir.
I just have a few questions for you. So you were asked to, as you described, you were asked to examine these bullets in this, that came from this Luger, correct?
I was asked
Ruger, I'm sorry.
to examine the firearm and compare it to those pieces of evidence, cartridge cases and bullets. Yes,
And that Ruger, that's a 9mm, correct?
that's correct.
And it's relatively small.
Yes, it is.
You examine a lot of different types of weapons, correct?
Yes.
And a 9mm, is that a fairly common weapon?
Yes, it's, I would say, one of the most common firearms that I examined.
A lot of law enforcement carry a 9mm weapon.
A lot of law enforcement does, yes.
And this particular one is relatively small in size, correct?
Yes.
And were the bullets that were fired from it small in size?
They're the same as all 9mm.
Okay. And you're not here today to offer to this jury that you knew what happened between Brodes Perry and my client Latoshia Daniels, are you?
No, I do not.
Your main thing that you're here to testify about today is that you examined those bullets, you examined the gun, correct?
Correct.
You tested the bullets, correct?
Yes.
And just to tell us that you can say that those bullets came from that gun.
That is correct.
And that's the extent of your testimony, and that's the extent of your involvement in this case?
That is.
No further questions?
Rita Rick.
No further questions, Your Honor.
All right, you may step down, sir. State, you may call your next witness.
State restroom.
All right, thank you. All right, I'm gonna excuse you at this time. The lawyer and I need to have some discussions, so I'm gonna show you excuse for a recess, okay? And again, we're still not ready to discuss the case.
Post some pads in your shirt for me.
You may be seated. All right. Are there any motions at this time?
Yes, Your Honor, at this time, we would like to make a motion for judgment of acquittal. As to count 1, first-degree murder, even in a light most favorable to the prosecution at this point, we have testimony that Ms. Daniels, when she arrived in this location, was happy to see Ms. Miss Archie. They were in an enclosed apartment together with no threats. Mr. Brodes Perry came home together in an enclosed apartment, no threats. And it wasn't until something happened outside of the hearing of Tabatha that the shots were fired. After the shots were fired, officers have described Ms. Daniels as being non-responsive. When Ms. Perry testified, she testified that Ms. Daniels was yelling, "He broke my heart." And so I would submit that as to the count 1, that only the threshold for voluntary manslaughter has been met. As to count 2, criminal attempt, first-degree murder regarding Tabatha Perry, Archie. Your Honor, I would submit that the proof has shown that Ms. Perry testified that when she and Ms. Daniels were interacting with each other, she had to say, "You shot me." Ms. Daniels said, "No, I didn't." She said, "Yes, you shot me." And Ms. Daniels said, "I didn't mean to shoot you." And Ms. Perry even told Detective Roberts that she didn't think Ms. Daniels was trying to shoot her when that happened. She suffered an injury to the far side of her shoulder, which would not be a lethal injury. There was never any threats between Ms. Daniels and Ms. Perry. There was never any animus. For Ms. Perry, Your Honor, I would submit that reckless endangerment at best is what has been established as to Tabatha Perry, Archie, which would then eliminate count 3, the employing a firearm.
All right, state.
State is opposed to the motion for judgment of acquittal. The testimony is that the defendant bought a gun on the same date that she showed up unannounced at Mr. and Ms. Perry's house. She brought that gun inside the house, and for whatever reason, there's no testimony that anything unexpected or that should have caused an unreasonable response happened. They were walking out the door after talking for a while. She turned around and shot him. She discharged the gun at least 7 times, hit him at least 5 times. In the midst of that, she shot Tabatha Perry in the shoulder. I assume the court is going to charge the jury that if your intent is to kill another person and you accidentally hit another person, it doesn't matter that it's what you were trying to do. And if you just unintentionally hit another person, it would still be first-degree murder or criminal attempt first-degree murder. And the pulling goes along with that. I think the evidence is overwhelming, and the case should go to the jury.
Your Honor, as to counsel's argument regarding almost a transferred intent, that may have been the case, I believe, if Mr. Brodes Perry had not died. But then to say she killed Brodes Perry, and in trying to kill Brodes Perry, she shot Tabatha Perry, that becomes a reckless action. The intent is here. It can't be on both. So, Your Honor, I would submit that as to Tabatha Perry, that transferred intent should not apply. Secondly, nothing in the indictment indicates that the state was pursuing a theory of transferred intent here. It says that in an attempt to premeditatedly kill Tabatha Perry, that this happened. It doesn't say anything about a transferred intent in the attempt to kill Brodes Perry. That would be an attempted felony murder. That's not a crime in Tennessee, according to State v. Kimbrough. So, Your Honor, I would submit reckless endangerment is where we fall as to Ms. Perry.
I'm not aware of any law that requires us to indict the transferred intent any specific way, and I would be interested to see if there's any that have been provided to the court. Again, the jury's going to be charged that if she were attempting to kill one person and hit another, and to say the fact that she was actually successful on her first attempt, on the attempt to kill Mr. Perry, that somehow negates the fact that she shot Miss Perry. I do not believe that's the law.
Your Honor, I can provide the court law that says if you're trying to shoot someone in self-defense and you shoot another person, that is a reckless act. You can't transfer the acting in self-defense against this person to the person that you accidentally shot. That becomes a reckless act, not that
But we're
intention.
not in self-defense though either.
And that's just an analogous situation. There is case law regarding, if you are trying to shoot one person and you don't succeed in shooting one person, but you shoot another person, then there's case law to support that. But when this other person also gets shot, then you end up in, I think, some double jeopardy issues with having the same intent covering 2 different crimes. I think the intent here is the allegation of premeditated. If there was an attempt to commit a premeditated act and someone else was injured, then that then becomes a reckless act.
All right, well, I have heard the arguments, and so the court's going to begin the analysis on the first-degree murder. The standard on a motion for judgment of acquittal is, after viewing the evidence in the light most favorable to the prosecution, any rational trial fact could find beyond a reasonable doubt that the defendant is guilty of the offense. And the court looks at the legal sufficiency of the evidence and not the weight of the evidence. So, first starting with first-degree murder. There are 3 elements for first-degree murder. 1, that the defendant unlawfully killed the alleged victim, Brodes Perry. The wife testified that she observed the defendant shoot Mr. Perry multiple times. Dr. Erica Curry testified that the defendant was killed by a homicide. So that element, there's enough evidence for that to go to the jury. And second, that the defendant acted intentionally. A person acts intentionally when it's the person's conscious objective or desire to cause the death of the alleged victim. I think from the evidence that's been presented, The defendants alleged to pull the gun out, shot the victim several times, and last, that the killing was premeditated. The evidence that has come in at this point is that the defendant purchased a gun in Sherwood, Arkansas on April the 4th of 2019, drove 3 hours to Memphis, went to the victim's residence, and shot multiple times. So looking at the evidence in the light most favorable to the state, the court finds that there's enough evidence for first degree murder to go forward to the jury. Looking at the second count, criminal attempt, first degree murder, as to Tabatha Perry Archie, one, that the defendant intended to commit the offense of first degree murder against the alleged victim Tabatha Perry, and 2B, that the defendant did some act intending to cause an essential element of first degree murder to occur, and at the time believed the act would cause the element to occur without further action on the defendant's part, and 3, that the alleged victim Tabatha Perry suffered serious bodily injury. The evidence, Ms. Perry testified that the defendant was shooting at the Mr. Perry, but she told Ms. Perry to get out of the way, and she shot, although she may not have intended to shoot Ms. Perry. There's something that is called transfer intent. And so, although she may not have had the intent to shoot Ms. Perry, she had the intent to shoot Mr. Perry, and in the process of that, Ms. Perry was shot. And so, also in terms of serious bodily injury, Ms. Perry Archer testified that her shoulder was injured. She said that she had pain in her shoulder. There was a bullet that was lodged in her shoulder that had to be removed. So the court finds that there's enough evidence for the criminal attempt first degree murder to go forward to the jury, looking at the light most favorable to the state. And last, count 3, employing a firearm during the commission of a dangerous offense. There's no doubt, that based off the testimony at this point, the defendant employed a firearm. Ms. Perry testified that she saw the defendant shoot the victim. There were bullets that were found inside of Mr. Perry, so employment of the firearm, that element has been met. The defendant employed a firearm in the commission of the shooting of Ms. Perry, the criminal attempt murder. The court finds that there was enough evidence for criminal attempt murder, and there was a bullet that was found in Ms. Perry's shoulder as well. And so, in the commission of her, in the commission of the gun being employed, Ms. Perry was shot. And last, that the defendant acted intentionally, knowingly, or recklessly. The defendant told Ms. Perry to get out of the way, and she shot the gun. So the court finds that there's enough evidence for each count to proceed to the jury, looking at the evidence in the light most favorable to the state.
Thank you, Your Honor.
All right, you're welcome. All right, are we ready on Momon?
No, I'd like to reserve a moment until after we have our first 2 witnesses, and Ms. Daniels has been able to hear all of the proof as it stands at that point for her to then make that decision.
Okay.
So if we could, after Dr. Bidding, take up the Momon hearing.
Okay.
And if I may just step out and make one quick phone call to make sure that we are good on logistics, we'll be ready to go.
All right, we'll take a recess.
Thank you, Your Honor.